All right, so this is just a We the People news, okay? One more time at it. Let me try to straighten this out a little bit. There we go. All right. I'm not giving legal advice, okay? At all. I may make my opinion, but no more, no less. I'm hearsay. And this video as well is hearsay. Do your own research, okay? There's this thing called implied consent. We need to research it. We need to understand it because most of the things we're doing wrong is implied consent. Okay? So, allegedly. All right. This one's going to be talking about the case in Georgia about the judge being in dishonor and acting in bad faith. And which I did a previous video, but this is going to be a different section with attorneys talking about it as here and now. Now, that being said, the armed attorneys, as it says there, all right, let's just go ahead and come through here, okay? Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. So some of my research, I actually look up attorneys. You know how I am about them. But I actually kind of go in there and see what they talk about and see how I can play along to get along and still protect myself, and what can I use different to convert, like Terry versus Ohio, right? That needs to be overturned. Why is it no attorneys actually challenging that as being unconstitutional to have it overturned? And if they are, why is not the Supreme Court accepting it? Well, we know why they wouldn't accept it, but I don't know if any of them really challenged it because it's such a good case for officers. All right, let's go.
So, Richard, you promised people the surefire 100% way to win. So how do you win over these terrible judges?
You don't go to court. Just don't show up. No.
No, not, oh, God bless.
We are the Armed Attorneys. Today we're going to be talking about some courtroom shenanigans and why, if you are legally and factually innocent, you might still be found guilty. We're going to review some clips that illustrate all these points. They're pretty fun.
All right. Again, not an attorney, do your own research, right? People. What do you think their ticket says not guilty? Why does the ticket say no contest? And why does the ticket say guilty? Because all three of them are guilty. Not guilty is not the exact same thing as innocent. All right? I'm not going to go in deep, but I did that one time. I had my case dismissed because I marked all that out and put a little box on there, checked it, and put innocent because I was innocent. All right? And they said I couldn't do it, and I told them, are you giving me legal advice? Well, it got dismissed. Now, that being said, it was never dismissed with prejudice. Should have double checked that at the time, but I was low educated on law. I would double check now. All right. But that being said, it does not mean the same thing. And if I can find the video, that was actually brought up from an attorney. So I hope I find it again and try to remember which one it was. I've been busy with 5 grandbabies and all that kind of stuff. But let's go.
We hope you enjoy this. And then finally, what is the guaranteed way to win in court every single time? That's our last one. But before we begin, show your support for the Second Amendment by hitting that like button. And today we're talking about Young Thug.
Yes, so this is, of course, over the last several weeks been widely discussed and circulated on the internet. Young Thug is in trial in Fulton County, and what's really notable about this is that his lawyer is maybe sitting out some jail time with him. So let's just take a quick look at his lawyer getting arrested.
Yeah.
No, I will not answer that. Why will you not answer that question? Because I want to make sure that what I say is accurate. I'm not trying to. No. I'm asking you, how did you get this information? I'm not telling the court. What I'm saying is based on information. Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems. We could have this. I have problems right now. Okay, I know. Look, I don't want to know about your problems, okay, at this point in time. All I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court, and for whatever reason.
So to be clear, alleged, got to cover it. Criminal. All right. Ex parte communication without him being involved, or even the clients and all that. Okay.
But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party.
What's an ex parte communication?
Ex parte. So anytime you communicate with the judge without the other side present, you have ex parte to the judge. Now there's other sorts of, there's ex parte motions and there's ex parte orders, but what we're talking about here is an ex parte communication.
Yeah, without the other party.
Right, just without the other party, right? So this is an ex parte communication. The prosecution here and a state's witness, I believe, had a conversation with the judge.
Now, the witness, my understanding, because I have not run through all this, give grandbabies right, the witness was not getting full immunity. So whatever he would say on that witness stand, come to find out, he could still be looking at more sentencing time because he did not have the full immunity that they would not give him. So he decided he wasn't going to play these games with them. And that's what the ex parte communication was, is to force him to be a witness, but would not give him immunity because it would be a federal case and federal charges later in the future could be brought upon him. So there's going to be a Fifth Amendment violation in there. And he's like, okay, wait a minute. If I be a witness to whatever, then I'm left up to myself to have some charges brought up in the future on me. And so he's saying like, no. This is not going to work. I'm just going to go ahead and sit out in jail.
Now, the defense attorney was noticed of this. And when this happens, it's actually the court is supposed to notice the other party.
Yeah, I'll say.
The court did not do that.
This happens. We have lots of great judges in counties we practice in. Galveston. If this were to happen to one of them, sometimes they just get accosted by opposing party in a hallway, and they can't
pull everybody back.
Yeah, they
disclose the nature of the conversation.
Yeah, exactly right. They'll let you know. They'll file something into the case. They'll have a phone call. They'll let you know, hey, guess what? Somebody came and tried to talk to me about the case.
Exactly. That is exactly what should happen. It is not what happened here. And so we have this contempt proceeding against this attorney who essentially is being demanded by the judge to disclose the identity of the person who ratted me out.
Yeah.
Tell me who did it.
Exactly right. Well, and it's so bizarre because it's one of those things where there's potentially a lot of different rights implicated for not just his client, but for himself. And we'll see this in a clip coming up in a little bit. But, potentially eavesdropping could be a crime. You have a right against self-incrimination. You have all these.
But eavesdropping is not a crime here.
Well,
I know it's there. I know they said it is there. But
yeah.
Thank God, because I will.
Texas is single party consent.
I was eavesdropping this morning.
Where are you?
Yeah, there was almost a fight in the lobby of our building.
Oh, interesting.
I was like pushing the open door on the elevator, like.
It starts buzzing at you.
Yeah, I know, right?
Too long.
Come on.
But all right, so we have this attorney getting held in contempt. The judge basically got caught behaving badly. Mm-hmm. Doubled down. Decided to arrest the lawyer for his own bad behavior. But, legal community, we've got people coming to his aid. Let's check out this clip.
And Judge, so that's what you want, but that does not conflate to a contempt. Your desire for...
And rewind this and all this and really listen to what she's saying. You'll learn something.
Him to answer your question does not mean that you have the power to hold him in contempt.
So you can come into court, Mr. Merchant, and not answer a question of the court and not be held in contempt?
If it's a question that the court is not permitted to ask, yes.
Okay.
So, she is doing some phenomenal lawyering, by the way, and you can see how far it gets her. It has gotten her nowhere. And so the main reason we wanted to talk about this, or that I wanted to talk about this,
If you had a good lawyer, you wouldn't.
all you out there who are like, when we're like, hey guys, don't do this because it's going to look really bad in front of a jury, and you're like, a good lawyer would make sure it didn't come in. Here we go, guys.
You got these guys sitting in black robes who beg to differ.
Exhibit A. It is, you can be the best lawyer in the world, and you can have that guy on the bench who is completely, not just, because lots of things are toss-ups, and it's a matter of if the judge thinks that it's more prejudicial than probative, and that's how it comes in or not.
It's balls and strikes without replay.
Right, but then you can have something that's actually, you are doing something unlawful, Your Honor, and they're like, take it up with the appellate court.
I can't tell you how many times I've heard that.
I know this is Fulton County.
Now listen to that, right? He cannot count how many times that's actually happened. Okay? Why? Why do we need to overram our appellate courts and or federal courts of lawsuits and all that just because the lower judges don't follow what the higher judges told them? So think about that, people.
This could have been Harris County any day of the week. It could have been basically any gigantic big city county. You are going to find more judges like this on the bench than good judges.
Yeah, I mean, we have statutes on the books saying...
Now, you hear people talk about this all the time, but do you actually hear attorneys talking about this? This is how you know you actually have good attorneys, is when they're calling some of these out. Like, no, majority of them is not doing what they're supposed to be doing.
If you're not convicted of the crime you're accused of, you get your gun back, and judges refuse it and say, take it up on appeal.
I know. I'd name names because I know he doesn't watch this channel, but he knows who he is.
Again, right there. Basically what she's saying is that there's a judge out there that is breaking what? The law or the rules, acting in dishonor. He basically puked on the court. I know you guys are thinking judges maybe the court, but the court's not judges. It's a weird setup. That's for liability crap. That's the reason why they keep using, it's my opinion, young sir. We're not allowed to go by and say it. There's all the facts. It's my opinion. It's a liability thing.
But going back to here, let's check out this next clip.
Judge, let's just back up for a second. He makes a motion because he has reason to believe that there were ex parte communications made. The court has a duty, if there are ex parte communications made, to alert counsel. He shouldn't have had to learn it from wherever he learned it.
I think that he caused that particular circumstance. I think that he had a conversation with somebody and he got some information that he shouldn't have had to begin with. So, Ms. Merchant, I'm of the opinion I'm going to stand on my ruling at this point in time. I'm going to hold it.
Boom. Boom. Right there. What did he say? What did he just say? I'm under opinion. He is escaping liability because of opinion. All right? This is the reason why they always use opinion. Now, she says the court has a duty. Well, what she's doing is saying the judge has the duty, but the judge also says that he's not the court, that the paperwork and all that in court is actually court. Okay? And so they get these weird, stupid playing games with people's lives about this.
And contempt.
I mean, judges have a duty to disclose this. He just completely disregards it. Think about that with any of your substantive due process rights in any other aspect in your trial. I mean, that's not a complicated rule.
No.
And apart from it not just being not a complicated rule that seems to be completely conflated, we have, a misunderstanding, it appears, of the entire contempt process in the state of Georgia. Let's check out this clip.
purge himself of the contempt just by telling me who it was, and he can do that this evening. He can do it. He can do it right now. He can do it at any point in time. If not, I'll revisit the circumstance on Friday.
And Judge, we would ask that you grant the bond. At this point, criminal contempt, he's got to be sentenced.
Well, his contempt is as long as he when he tells me what the basis of the conversation was. I didn't ask what, but he tells me that, then I can certainly he purges himself of the contempt.
Then that's civil, Judge.
That's civil contempt.
That's civil.
And that's respectfully, I would point you to In Re Hughes, which stands for the same point of law. Civil contempt imposes punishment as a means of coercing future compliance with the prior order of the court. Here, the prior order of the court presumably is that you have directed Mr. Steele to answer the question, to disclose the information as to who is his source for knowledge of this ex parte meeting that occurred earlier today. Criminal contempt imposes unconditional punishment to punish the act which has occurred in the past and cannot be purged. It is not capable of being purged, in which case what Ms. Merchant said applies, which is that there is a 20-day maximum sentence and $1,000 fine. It is, for all intents and purposes, a misdemeanor offense, Judge.
Yeah, so from what I gleaned from this, and from what...
So go back and hear this out and get this really understood. Because if attorneys can actually call this out on judges, so can we, the people. When you represent yourselves, what you guys call representing yourselves in court, you can do this as well. Okay? I may have been too much of a headache, and it just meant it kind of tossed me off into the side and didn't want to deal with the situation for such a minor thing. If it was a bigger thing, it may be a different story when it happened with me.
I understand we have something very similar in Texas. Criminal contempt, you're punishing...
Richard's pretending like he's never been held in contempt.
You're punishing that, hey, I saw you do the bad thing, bad lawyer, you're getting punished for that thing, as opposed to a civil contempt. I think they're both criminal here, and we just call them slightly different things. I don't know the names of them.
Yeah, there we go. Again, these are Texas lawyers, right? Everything in Texas is actually criminal. So we do, even our speeding tickets or any type of tickets is criminal. When it's criminal, you're allowed to go through the criminal process, right? And this enhances reason why I say, even fight your tickets in criminal, due to actually learn criminal law, because everything in Texas is actually criminal, and the magistrate, the judges, prosecutors, all of them are ignoring Texas criminal law. 14, 15, and 16, and a couple of others. But them are the main ones that you want to know they're violating. So read the 14, 15, and 16 that they're actually clearly violating.
But whereas this judge is saying, hey, he can purge himself of it, it looks like he's kind of conflating the process.
Yes, and this is, again, this judge doesn't even understand the law. The judge himself doesn't understand the law and refuses to be educated on it. And that is what we see. And if you think that it's, surely they understand something as nuanced and rarely used as self-defense law better than they do contempt law. No. It is a wild world out there trying to educate judges on self-defense law. We have bench briefs to submit and we do our darndest, but when you have a judge who is just willfully ignorant, it's what you got, and you got to take it up with the appellate court. And that is a terrifying prospect because you're probably doing it from a prison cell.
Yeah, and I think there's two, and we'll link the full videos in the description. I do think there are two kind of funny things worth pointing out when he says, respectfully, Your Honor, and then the other one, as the court is aware. Those are big signals to judges. Hey, I know you didn't read this, or you're getting this completely wrong. I'm really trying to help you out here and point you in the right direction. And so, even using all the lawyer tricks, it didn't seem to help them out too much.
No, it did not. Well, some people can't be helped.
No, but
Help me help you, Judge. But it's just not happening.
you can lead a judge to water. You can lead a judge to justice.
Yep.
I don't know.
So, Richard, you promised people the surefire 100% way to win. So how do you win over these terrible judges?
You don't go to court. Just don't show up. No.
No, not, oh, God bless.
You don't find yourself in court.
Yes, that is.
It's like the win every fight you don't have. This is one of those fights you just don't want to have.
That's exactly right. And for all of the people we talk to who are like, basically like, well, my pride and my ego, and I would never let this happen to me, and I'm going to take my chances. Don't take your chances. Don't. It is not. When you, I think, truly understand what you could be up against, you have to be that bigger man every time. You've got to de-escalate. You've got to retreat if possible, because like no one can save you